today we are witnessing a very interesting development in international human rights law, which is usually referred to as the development of a jus commune, a common law of international human rights. And by this we mean that mostly international courts or judicial or quasi-judicial expert bodies refer to one another, read one another, influence one another in how they interpret international treaties protecting human rights, that in most cases, being all derivated from the Universal Declaration of Human Rights, are very similar in their wording and in the protection that they provide. And so what we see is, as a result of this dialogue between different judicial and quasi-judicial human rights instances, we see an increasing role for comparative human rights law in international litigation. By this I mean that if you present a complaint or a communication before the Human Rights Committee, for example, it shall be very useful to refer to what has been said by the European Court of Human Rights in a similar case. It shall be very interesting for the Human Rights Committee to understand what was done by the Committee on the Rights of the Child in a similar instance. It shall be very interesting for the Human Rights Committee to learn about the case law of the Supreme Court of Canada or the Bundesverfassungsgericht, the German Constitutional Federal Court. All these instances are influenced by each other, and they try to provide a protection to victims that is at least as strong, as effective as the protection provided by other similar instances. And so there is a sort of emulation going on, almost a competition between these different human rights instances in order to develop international human rights law. And the role of NGOs today is for the most part to develop an understanding of this comparative jurisprudence, to allow it to move forward and to stimulate this emulation between different human rights instances in order to allow for the progressive development of international human rights law.